Welcome to my channel, Legal Jargon. In my channel, I would be discussing law-related concepts and other current affairs updates relevant for cracking judicial services exams and other competitive exams. I will also be discussing the important articles in the editorials of The Hindu as well as the Indian Express. Please like and subscribe my channel and don't forget to hit on the notification bell. In today's session, I would be discussing the editorial synopsis on the topic Information Technology Rules for Tech Giants. In this session, I would be discussing four important articles. The first one is Ending Encryption on Enforcing Traceability on Popular Messaging Apps, published in the June 1st editorial of The Hindu. The author discusses the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, and after it has come into force, that WhatsApp has moved to the Delhi High Court against these rules, especially the ones that mandate social media giants, primarily in the area of messaging, to identify its first originator of information on its computer resource as may be required by the judiciary. A significant social media intermediary is one which has more than 50 lakh registered users, and WhatsApp Messenger service would classify as one. WhatsApp's arguments are that for compliance and traceability, it will have to break its end-to-end encryption service that allows messages to be only read by the sender and the receiver. This will violate the privacy of the people. The author asks the question whether traceability guidelines by breaking encryption are vital to law enforcement in cases of harmful content. Based on a recent release by the Ministry of Electronics and Information Technology, traceability measure can be used by the law enforcement as a last resort and can only come handy in certain situations like prevention, detection, investigation, prosecution, or punishment of an offense related to sovereignty, integrity of India, or child sex abuse material punishable with imprisonment. The author emphasizes the Puttaswamy judgment and clarifies that any restriction on privacy according to the judgment must be necessary, proportionate, and must include safeguards against abuse. The government can already seek access to encrypted data under Section 69, Subclause 3 of the Information Technology Act and Rules 17 and 13 of the 2009 Surveillance Rules that require intermediaries to assist with decryption when they have the technical ability to do so, and when law enforcement agencies have no other alternative or options. Under these existing rules, the government can seek unencrypted data, metadata, and digital trials from intermediaries. The author argues that government agencies could misuse users' identity on vague grounds and compromise with the anonymity of whistleblowers and journalist sources who are acting in the interest of the public. He says that the government, instead of revisiting its position on traceability, must revise its existing Information Technology Act 2000 in accordance with the best global practices. The next article which I would be discussing is Power Play to Bring the Digital Ecosystem to Heel, written by Rishabh Bailey and Vrinda Bhandari in the editorials of The Hindu, published on June 1st, 2021, where both the authors criticize the new information technology rules as not the way forward. They specify that Rule 4, Subclause 2 of the Information Technology Intermediary Guidelines and Digital Media Code Rules 2021 that impose an obligation on social media companies that provide a message function to ensure traceability of the originator of information posted on their platforms is against privacy. They also discuss that the new rules hold these intermediaries responsible for illegal content posted on their platforms. A result of which, WhatsApp filed a petition in the Delhi High Court alleging the mandate for traceability violates the privacy rights of citizens of India. In response, the government, through a press release, stated that privacy is not an absolute right and traceability obligation is proportionate and sufficiently restricted. The new rules mandate traceability apply only in the case of social media intermediaries that meet a threshold of 50 lakh users, where WhatsApp falls in the boat. The authors also focus on the two Puttaswamy decisions where the right of privacy was discussed, 2017 and 2018 decisions. The Supreme Court held that privacy is not an absolute right and clarified any restriction in the right must be necessary, proportionate, and shall include the safeguards against abuse. The authors say that the rules lack effective safeguards as they fail to provide any system of independent oversight over the traceability mechanisms imposed by the government. The government agencies are given the ability to seek any messenger's user's identity virtually at will. Deciding to remove anonymity requires application of a independent judicial mind, which is absent in this case. Universal consensus is that traceability mandate would compromise privacy and security of all individuals at all times. Even if there is no illegal activity on their part, it would create a presumption of criminality. The authors argue that there are already means existing for regulation. The Justice B.N. Sri Krishna Committee report of 2018 provides that surveillance powers of the government are vast and overreaching. If we look into the Information Technology Act, government already has the ability to access encrypted data. Under Section 69, subclause 3 of the Information Technology Act and Rules 17 and 13 of the Information Technology Procedure and Safeguards for Interception, Monitoring and Decryption of Information Rules 2009 require intermediaries to assist with decryption when they have the technical ability to do so and where law enforcement agencies have no other alternatives. The newly notified rules punish relevant intermediaries for failing to adequately weaken encryption systems. The traceability-related provision in a draft version of the rules released in 2018 faced significant opposition from numerous stakeholders, ranging from service providers, academia, and civil society organizations. The new traceability provisions also are similar and reject all sort of objections to state interests. The authors argue that the new rules should have also been put through a period of consultation before being notified, where an explanatory memo explaining the rationale for regulation should have been made. The ability of the government to issue progressively more onerous obligations under the guise of due diligence requires under Section 79 of the Information Technology Act be subjected to judicial scrutiny. The move by the government is a part of a broader power play against the foreign-based technology companies and to bring the digital ecosystem to heel. The ill-considered regulations imposed upon the new intermediary rules, according to the authors, appears to have little basis in evidence or care for consequences and is not the way forward. The authors call for legislative change and a long-term solution where they want the government to revamp their antiquated Information Technology Act 2000. The next article which I would be discussing is Tech Giants Must Follow Indian Law written by Bhupender Yadav, published in the Indian Express Opinion on June 1st, 2021. This article, unlike the previous two articles, favors the newly framed IT rules framed by the government. So now let us look at what are the arguments which are in favor of the government framing the newly framed IT rules, and how is it favorable to the Indian citizens. The author states that the venue of seamless social media has caused an exponential rise in hate crimes, fake news, propaganda, and libelous content. This also holds true for the instant messaging services that we have today. Since India is the world's largest democracy, India has always welcomed social media companies to do business in the country. In fact, even people have used these platforms to question the government and further strengthen India's democratic fabric. Even the BJP government under the leadership of PM Modi has supported its use. Prime Minister Narendra Modi has himself used social media platforms to actively listen to people and be heard. Then the author asks the question, the problem lies with the misuse of social media. Social media giants function with arbitrary policies, not only as platforms for idea exchange, but also as censors. Their algorithms can be manipulated to only play certain content and not play the other forms of it. These platforms are themselves deciding what is acceptable content and what is not. For example, the recent case is the origins of coronavirus. American social media platforms, Twitter as well, muzzled the discussions around this issue. The Government of India has recently decided to revise the Information Technology Intermediaries Guideline Rules 2011 by Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021, notified on February 25th, after consultation with all stakeholders. But the companies do not want to comply and have taken the defense of freedom of expression of Indian people and violation of privacy. Congress and other opposition parties have become spokespersons for these private companies. When objectionable photos are being shared on these platforms and the reputation of people have been spoiled, even on an iota of evidence against them, the new IT rules aim to provide such people protection. The new IT rules make it mandatory for companies to establish effective grievance redressal mechanisms for resolving complaints from users to victims. They are mandated to appoint a grievance redressal officer to deal with the complaints and share the name and contact details of such officers. The complaints have to be acknowledged within 24 hours and have to be resolved within 15 days of the receipt. Even to ensure the online safety for women, the law requires these social media giants to remove or disable access to content that expose private parts of individuals or contain full or partial nudity or a sexual act, or even acts of impersonation, including morphed images, within 24 hours of the receipt of complaints. So therefore, the author is praising these rules as they are effectively dealing with such issues. And any complaint can be filed by the individual or any other person on his or her behalf. The new IT rules classify social media intermediaries into two categories: social media intermediaries, SMIs, and significant social media intermediaries, SSMIs. SSMIs comprise companies more than that meet the threshold of 50 lakh registered users such as Facebook, Twitter, Instagram, and other SSMIs. The new IT rules direct the significant social media intermediaries to appoint Chief Compliance Officer, Nodal Contact Person, and a President Grievance Officer, all Indian residents, to ensure compliance with statutory provisions and act as a 24/7 coordination with law enforcement agencies. These rules call for the identification of the first originator of the information by the significant social media intermediaries for the purpose of prevention, detection, investigation, prosecution, or punishment of an officer related to punishment of an offence related to sovereignty and integrity of India. The information made available is necessary to prevent threat to public order where offences such as rape, sexually explicit material, or child sexual abuse can take place. In US and UK, the very same companies, when asked for origin of messages, have circulated them regarding terrorism. Now, in India, the same companies are exhibiting their objections and biases. It is quite shocking that these companies have not made any rules and have never tried to work in tandem with the law enforcement agencies in India, such that the platforms are made safe for use of women and have ensured mechanisms to stop misuse against women. In response, these tech giants have turned around and started accusing Indian government of denying the freedom of expression of people. This is an act of sheer hypocrisy, according to the author. The onus of protecting the freedom of expression and the privacy of the Indian citizens is on the democratically elected government of India. No unelected for-profit foreign organizations that have zero accountability to the people of India can dictate terms as to the Indian sovereign. These tech giants must understand that they cannot undermine the strong foundations of the world's largest democracy by not complying with the Indian laws, is what the author concludes with. The next article which I would be discussing is who gets to decide what is legitimate free speech, big government or big tech, written by Bhaskar Chakrabarty, published in the Indian Express Opinion on February 27, 2021. This article gives us a neutral approach to understanding the new IT laws. It gives arguments in the favor of both the Indian government as well as the big tech companies. So let us start to understand this article. The author starts by saying the Indian government announced the new IT rules which make the social media platforms more responsible and more accountable for the content they carry. But he states that the list of deemed offences stuff prepared by the government is very long, and any posts that threaten the unity, integrity, defence, security or sovereignty of India, friendly relations with foreign states of public order, or cause incitement to the commission of any cognizable offence, or prevent investigation of any offence, or insult any foreign state will be subjected to judicial scrutiny. So one has to be, or removed. So one has to be careful about the hilarious posts that one posts on WhatsApp. The government is giving itself plenty of room to cut big tech down to size, and the timing of the announcement is perfect. At a time where Indian government is facing a scuffle with Twitter. The Indian government a few months back ordered Twitter to remove some of its accounts and tweets in support of farmers' protest to be blocked. Twitter refused by saying that it wouldn't comply with such orders as it is inconsistent with Indian laws. The interesting thing about these new regulations that it could make a blocking order a legal demand, which is a graceful way of dealing with the situation according to the government. The author states that these social media companies having millions and billions of followers control the crucial levers of modern times: data, attention, and popular narrative. The Indian government has joined other governments around the world and has found a common adversary. Motivated by the harms done by the infodemic of COVID-19 untruths, misinformation relating to drugs, elections, and fallout from the siege of the US Capitol on January 6, major platforms have tightened their rules. Now, even US presidents can be deplatformed for that behavior. For example, Donald Trump is banished from Twitter and Facebook. Social media companies argue that their actions are ad hoc, inconsistent, and reactive. They are already lining sandbags before antitrust mechanisms arrive. So the author asks the question, who is to decide what is legitimate free speech, big government or big tech? According to the author, even big tech companies are framing their own rules as to what is good and bad behavior. So that is why the question arises. The argument for government intervention is that it is never in the interest of the big tech companies to remove offensive speech, as the more the content goes viral, the more revenue it will gain. The counter argument to this is that the companies are getting smarter about the risks of allowing such content on their systems, and they eventually remove such illegal content. The second argument in favor of the government is states are the guardians of public interest, and in democratic societies, governments are elected to represent the will of the people. So the governments have to make a hard choice regarding curtailing of speech or permitting it when they are acting as a public guardian. The counter to this argument is even democratically elected governments are far from perfect, and in accordance with the Economist Intelligence Unit Democracy Index, both India ranked 53rd and the US ranked 25th are flawed democracies. Another argument is the government agenda is set by prominent personalities, having large social media followings, giving too much power to create their own viral narratives while shutting down competing ones. This argument is against the government again. Argument in favor of the big tech. Well-functioned markets are superior to flawed democracies in optimizing social welfare. That the market settings determine what is good or bad. The counter argument is the tech industry is deeply flawed, and there is a lack of sufficient choice of platforms. There are asymmetries in power between companies and users, and the big tech is amassing data on citizens and using this information for its own purposes, making the disparities even greater. The industry is being utterly inconsistent in governing what speech is allowed and what is to be blocked. The third perspective, which is looked into by the author, is that it doesn't matter who is the true upholder of public interest. For all practical purposes, the outcome of the struggle between the big government and big tech will be determined by relative bargaining power. Governments technically have the ability to take entire platforms offline within their boundaries of their countries, and these platforms have also become so enormous that their users are revolting. That is why we have witnessed Google and Facebook threatening to deplatform Australia. We live in a new era of global diplomacy where not just states are butting the heads with other states, but there are also gigantic tech companies who are throwing their hats into the geopolitical ring. So the author is basically saying that even the big tech companies are having as much negotiating powers as the states. because their users are huge in numbers. Any government, including Indian government, can form these companies to do their bidding arbitrarily. Must recognize that the new dynamic of bargaining power between the big government and the big tech. So the author is saying that the Indian government, it's high time for Indian government to realize that even these big tech companies have high bargaining power, and it is not so easy to regulate them. When India recently imposed a ban on TikTok, it lost many of its followers. And TikTok lost many of its followers, and the politicians' children were deprived of endless hours of entertaining videos. If Twitter is regulated, then Prime Minister Narendra Modi would instantly deprive himself of 66 million followers. Twitter knows this, and even the negotiators within the Indian government know this.